Good morning, friends. Today we are going to discuss regarding the prescriptions given by the doctors. Yesterday, Odisha High Court, single judge S.K. Panigrahi bench, while disposing the bail petition of you can know this case as Krishna Prasad Mandal versus State of Orissa, while granting bail in bail application number 3541 by 2020, asked the State of Orissa, asked the Chief Secretary of the State of Orissa to issue circular to all the doctors to write the prescriptions in capital letters, in bold letters, in separate letters. That means the letters should be legible, visible, clear and understandable by everybody. Because who are the people concerned with it? Number one, the patient. Number two, the pharmacist. Unless the pharmacist understands what is written by the doctor, he will give some other medicine. Then prosecutor and also the judge. These people who are dealing with the chits or prescriptions normally maybe with the handwriting of the doctors, they are facing much difficulty. Therefore, the Odisha High Court has directed the Chief Secretary to give a circular to the doctors. Of course, this is not the latest issue. The issue has been pending right from 2015. Even in 2015, that the then Minister J.P. Nadda, he stated that the center has amended the so-called ICMR regulations or rules, right? And they have given instructions. And of course, the problem here is, even though the instructions are not followed, no punishment is mentioned except Jharkhand High Court. We will come to that later, right? So, please refer to the Code of Medical Ethics regulating Medical Ethics Regulations 2002. It has been amended in 2016, right? So, this is called as Indian Medical Council Professional Conduct, Etiquette and Ethics Regulations 2002, right? So just like our legal ethics, etiquette and conduct, as we have got rules, same thing, the doctors also have got rules. In this rule, in particular attention should be paid to Article 142. That means 1 subclass 4 subarticle 2. It is actually an amendment in 2016. So the doctor's prescriptions, so if they are in writing, it should be clear. It should be in bold letters. That means capital letters, and they should be legible. Right? Now just go 1.5. That is rule number 1 within bracket 5. Use of generic names of drugs. The doctors, the simple for that matter, physician. Every physician should, as far as possible, prescribe the drugs with generic names, right? And shall ensure that there is a rational prescription and use of drugs. This is more important, right? The generic name should be written. Otherwise, suppose for example, if you go to the doctor with a fever, normally he has to prescribe the paracetamol, maybe Dolo or something. But this Dolo will cost about some 10 paise or 20 paise. Whereas he recommends so many sugar-coated pills, beautiful names he will write. But at the same time, he has to write the generic name so that the people who are conscious of the generic means composition will be the same. So definitely they will get for a cheaper rate, is it not? Therefore, these points are more important. Number 1, of course, our point is concerned only to the prescription. Prescription should be visible, legible, clear, should be written in bold letters and should be understandable by even the common man. This is what the Odisha High Court has given instructions to the Chief Secretary. Right? Now, of course, since the time has come, I want to give you another thing since we are related to human rights. So please refer to rule number 1 within bracket 6, human rights. The physician shall not aid or abet torture. So this may be happening in cases of so-called insanity. Suppose there are some people who collide with the doctors and admit the patients as though they are insane, as though they are suffering from unnecessary diseases, all these things. So they manage, they will put them to torture also. So never, the doctor should not aid or abet. Aiding or abetting. Abetting means by giving injections. Abetting means supporting. Nor should he be a party to the infliction of mental or physical torture. So you should not do these things. If you go to the TV serials nowadays, we have been seeing them, because the of course the villain lady, she admits a woman of good as though she is insane, as she is mentally disturbed, and cause a lot of physical trauma or concealment of the fact, and they cause torture. So this should not also be done. Of course, since the time has come, otherwise it has no relevance for this case. Now, so the doctors, you may be knowing the instructions of the ICMR, Indian Council of Medical Regulation. These instructions are there, right? But the problem is no punishment is prescribed except the Jharkhand High Court. So Jharkhand High Court last year, it stated that if the doctors do not write the legible and clear names, then if the instructions or directives are violated, for the first time they will be warned. For the second time, they will be suspended for certain period. And if it continues for the third time, normally the registration will be cancelled. This is the direction given by the Jharkhand High Court. Whether it has followed the directions or not, but it has given at least a sort of a threat to the doctors. Of course, no use, because now in general we know. So the doctor's handwriting will be known only to the pharmacist. That too, pharmacist of his medical shop, not to others. This is a practical thing, right? So the doctors are governed by such other acts. So please remember. So Drugs and Cosmetics Act 1940, then Pharmacy Act, already a Clinical Pharmacy Act, last time I told you, 1948. Then NDPS Act 1985, Drugs and Magic Remedies, that is so-called sale of objectionable these things. 1954, it was amended also. So drugs and magic remedies means suppose if Amitabh Bachchan says that you please use this hair oil and your hair will grow. If the hair oil doesn't give the required result, then Amitabh Bachchan will be taken to task. That is the use of the so-called Drugs and Magic Remedies Act, with which the false advertisings actually had come to a stop. Now coming to our present case. So this is a bail petition filed by Krishna Prasad Mandal, right? He was in jail, and the advocate on his behalf stated that the investigation has been completed, the medical certificate is also obtained, the injuries are quite simple in nature. So the Honorable High Court wanted to go through the prescription, go through what was written in the case chart of the case. So for this, the court has found very difficulty. The court found it difficult to decipher the medical records, right? Because the writing was not at all good. It was found that the prescription by the doctor is of pathetically, normally pathetic incident and all, pathetically poor legibility, and far beyond the comprehension of any common man. No common man can comprehend or understand, or even of the court. Of course, court cannot understand. Of course, here the problem also we have to think. Certain doctors, even certain people have good handwriting. Even I do not have good writing. I do not understand what I have written. Once again, I see back. Normally, certain words they will be missing. So this problem is also there. But anyway, you have to write in capital letters. That's good. So such illegible handwriting in medical records, it has got the propensity to have adverse medico-legal implications. Is it not? Suppose he writes something, but if the typist understands it another way, or if the court takes it in other sense, then definitely adverse inference will be taken and the case will be destroyed, right? So, however, at least there is a saving. The learned advocate for the petitioner, that means for the person for whom the bail application is filed, he has yes, with much difficulty he could decipher what was written therein. That means at least there is an attempt on the part of the so-called advocate to decipher what was written, right? Now, the feeling of the court. This court feels that it is imperative that the entire physician community needs to go to the extra mile, and make conscious efforts to write prescriptions in good handwriting, preferably in capital letters, says the judgment read. Okay, right. So when I contacted the doctor, he says, how is it possible, sir, to write in a legible, clear way? Normally, we have got our own style of writing, handwriting. We have got our own style of writing. Normally, it is understood by the doctor. What is the purpose of the prosecutor? To understand the same, he has put the question. I said, Baba, if some case is taking place, the trial is taking place, definitely the court has to know what you have written, particularly in the name of injury certificate, in the name of PM certificate, all these things. Previously, when we were officers, we used to get them typed, of course, to the dictation of the doctor. I used to go to the doctor and write. I used to get doubts prior to that itself. Then if I ask him, he will put the words and then I used to get it typed and clear. But nowadays, due to this Xerox or fax, all these things have come. So copies are straight away being produced in the court, and the court is also facing much difficulty in deciphering or understanding or decrypting the language of the court. Right? So please remember, the days have changed. Nowadays, we have come to the digital era. So normally, whenever a person comes and the doctor prescribes medicines, he can get them typed simply. Then in such an era, digital era also, definitely it will throw open several options to make pre and pre-diagnosis, pre and post-diagnosis even by the patient, and it should be patient-friendly. Whatever medicines you prescribe, better get it typed. If it is typed, it will be happy so that he can show it some others, or he can if he clicks the name of the medicine in the Google, he will get its effect, its results, all these things he can know. That means it will be patient-friendly, right? So ultimately the court says, such illegible writing in medical records, it has got the bad effect of tarnishing the case. Therefore, it is imperative that unless the physicians change, so unless they change their attitude and start writing in capital letters, this will not actually stop, and therefore some action has to be taken. Of course, let us see what action will be taken by the Orissa High Court. Of course, lot of circulars have been given by the ICMR. Of course, since they are the regulating authority, they should make some efforts. That's where I am telling you. So ICMR, it's not a toothless organization. So they will be giving so many directions to the doctors. So regarding PPE kits, all these things. They must say, if the doctor is found not writing the capable words, he will be fined, he will be warned, he will be suspended. Do some suspensions state nationwide, 1 or 2 days. Normally doctors will come down, they will start writing. So to make them bend or to make them come in line, it needs definitely guts in the hands of the central government. Of course, since the doctor profession ICMR relates to center, even JP Naddas are also stated, yes, he will. So implementation is the main problem in India, and if it is implemented, definitely people, particularly the patients, will be benefited. So friends, remember, ultimately the High Court says or asks the doctors to write the prescriptions in capital letters at least. Thank you.